While there are no officially formally accepted scoring challenges, I would ask the courts to consider a few things that maybe should be taken into consideration. The sentencing guidelines is set up to where it's a points-based system, to where an individual offender is given various points for things that make him or her in need of a higher sentence. The more points they get, the further along a grid it moves, the higher the sentence gets. We think that there is some room in this very unique case for some adjustments to that scoring. The scoring gives points for felonies. We would ask the court to recognize that one of Mr. Mitchell's felonies that accounts for his scoring is a child support felony. That's not, I don't think, the normal kind of felony contemplated by these guidelines. More importantly, we would ask the court to consider some mitigating factors that maybe should subtract from Mr. Mitchell's points that he would have gotten, namely that Mr. Mitchell is a veteran of our armed forces. He served his country with distinction and pride. Also, this court has been watching Mr. Mitchell for quite some time now. This case was unique in some lab issues, and he's been on probation with this court for on bond with this court for nearly 2 years now, and we haven't had an issue with him. We would also note that Mr. Mitchell, Marty, I got to know him early in January when I came onto this case, and the man who's sitting next to me right now is not the same Marty that I got to know. Marty has since taken accountability for this. With his plea, he has admitted to the court his wrongdoing. Marty's also been very actively involved in getting help with the VA. He was homeless. He is now housed. He wasn't taking care of his medical situation, but he is now. He is working with the VA doctors for his physical as well as his mental health. He has, in a sense, enveloped himself with the veterans who can understand a very unique situation that Mr. Mitchell has that most of us walking the streets can't. That's a post-traumatic stress issue that only the veterans can. And, Your Honor, we would ask that the court, in its sentence, and Mr. Mitchell recognizes he's going to get a sentence, but we would ask that the court fashion a sentence that allows him to continue to be able to work with these programs and to take care of his medical issues. He has a blown hernia mesh right now sitting here. He has surgeries and injections scheduled for his spine. These types of things are potentially capable of being done if he is able to be furloughed from a local jail, as opposed to their much more difficult.
Right away, the defense shifts the focus away from the crime itself and onto the man behind it. In sentencing, this is called presenting mitigating factors, details like military service, homelessness, and mental health that could convince the judge to show mercy. But here's the big question. Can a difficult past outweigh repeated criminal behavior?
They're much more difficult to accomplish from a prison, as well as continuing to Zoom and work with his mental health professionals at the VA and continue the VA treatment that is being very good for Marty and bringing him along. We do recognize there are some allegations relative to new conduct, but again, I would note that that new conduct isn't within these last 6 months since Marty's been working with the VA, and we would ask that the court not consider that because those allegations haven't been proven. There has been no guilty finding on those. Those are pending, and he should be treated as innocent until it is proven that he's guilty. So we would ask that the courts reduce or look at the lower end of those guidelines and sentence Mr. Mitchell to the local jail to allow him to continue his path towards bettering himself. Thank you.
Mr. McGraw. Mr. Mitchell, it's not required that you would say anything today, but it is allowed. Is there anything you want to say, sir?
I can't really speak.
Okay. Ms. Miller, any recommendations from the people?
Thank you, Your Honor. Mr. Mitchell is 54 years old. He does have a criminal history that goes back to 1991. This is his fourth OWI conviction. He notably was on probation for a 2020 OWI third when this offense occurred. I believe there's a bench warrant out of that case for him not addressing that probation violation. I would also note that there is a new warrant from 2023 for a misdemeanor malicious destruction of property between 200 and 1,000 that occurred after this case was charged. This is a case where Mr. Mitchell was stopped And while he was dealing with the officers, specifically regarding the insurance, he decided to drive away from the traffic stop. He pulled away from the officer while she was standing next to the vehicle, because he didn't agree with the way that the officer was conducting the stop. He wouldn't get insurance, he wouldn't agree to be towed, and so he drove away from the parking lot, locked himself in his vehicle, and required numerous law enforcement agencies to have to respond to finish the traffic stop. There was MSP and someone from St. Ignace and the Sheriff's Department, and this went on for an extended period of time. Finally, when the law enforcement started to try and break the driver window, that's when Mr. Mitchell opened the door to stop them from breaking his truck window, but then it took all these officers to pull him out of the truck. So I think this was a pretty significant incident. He was under the influence of marijuana at the time of the stop. He had 5.1 nanograms of THC in his blood. When the lab report came back, there was marijuana in the vehicle with him. I do note that the guidelines are 12 to 24. I do think that there are some factors that would make this a appropriate sentence to prison. I think the fact that he was on bond for a felony OWI when this occurred, that probably stands out the most to me. That being on felony probation didn't stop him from committing another OWI third, which is public safety issue. The fact that he was on bond in this court and he got another case and there's a warrant for that he hasn't addressed. The fact that his criminal history goes back many years and there's many convictions that he obtained while he was on probation. So it doesn't seem like he has a track record of being able to comply with probation. Probation doesn't seem to stop him from getting new convictions. I certainly think that a sentence within the guidelines would be appropriate in this case. Thank you.
Thank you, Mr. Mitchell. If you please stand for the court sentence.
Your Honor, Mr. Mitchell has indicated that he has composed himself and would like to address the court.
Absolutely. Go ahead and stand up and tell me whatever you want.
I'd like to make some reference to the stop itself, Your Honor. Okay. With advice of my attorney, I would just like to say that thank you for being cooperative with me so I can get my medical stuff taken care of. And just may God bless us all. I'm going to do what I got to do.
Thank you. Well, Mr. Mitchell, there are some financial assessments. There's $130 in the crime victims assessment, $68 in state costs. There's $350 in court costs assessed, $200 in an OUID reimbursement, and a $500 fine. And in terms of the incarceration component, the advisory guidelines are scored at 12 to 24 months. Your attorney pointed out some things that aren't necessarily accounted in there, the nature of the prior felonies, and he's correct about that, other than whether they're serious or whether they're high severity or lower severity. And so one of those is for child support, and that's not only a low severity crime, but really wouldn't factor a whole lot in driving incarceration sentence for a later felony. But by that same argument, what the prosecutor pointed out is a super compelling point. You come before a circuit court, Mr. Mitchell, on probation for felony repeat driving while intoxicated. Not only as a probationer for that, but as a probation absconder. And while you're a probation absconder, while you're on probation, you're a probationer for felony repeat intoxicated driving. You drive intoxicated. And you had 8 felonies and a habitual 4th notice dismissed. You got a significant benefit from the plea bargaining process. And you're here today. And if somebody's on probation for intoxicated driving, felony intoxicated driving, and they do it again, that's a compelling factor. That is not actually taken into account in the guidelines. You've got 2 outstanding warrants right now. I don't know what you think will happen when you show up to see a judge when you've got warrants because you're thumbing your nose at other courts. You've got a poor history on supervision. You've been charged with other crimes while you've been on bond. So you've been on bond a long time, but I disagree that we've had no problems. No problems would be, how about not getting charged with more crimes? How about not absconding on a felony probation? Those facts are not taken into account in the advisory guidelines. I think they're grounds to exceed them. And Mr. Mitchell, I'm going to commit you to the Michigan Department